Do I need to pay the bills of my deceased loved one in Missouri? Here's what you need to know. So, somebody recently passed away that was close to you, and you're finding bills, or people are chasing you for bills. It could be credit card companies, healthcare companies. Anybody could be out there chasing you for money right now saying, hey, we know that so-and-so passed away, and we'd like to be paid. Well, my name is Dan Schnurbush, and I'm a probate attorney, and I own a law firm here in St. Charles, Missouri, where we serve clients in probate estate administration and trust administration all across the state of Missouri. Now, in this video, we're going to talk briefly about how creditor claims work in the state of Missouri. When is somebody obligated to pay on it? When are they not? How do we generally handle these in Missouri? So, to start things off, the most important thing to understand about creditor bills in Missouri is that you don't owe those. The estate is responsible for paying those bills, generally. The only time that you could ever be responsible for the bills or the debts of a deceased person is if you're a co-signer on that account or property. I shouldn't say the only time. In general, the most common times that you're going to be responsible on a debt is going to be if you're like a co-owner of a credit card, or you're a co-signer on a mortgage or a loan or some other debt, where you are personally responsible in addition to the deceased person. But for anything where it's an obligation just of that deceased person, like a credit card only in their name, or a medical bill for their care that has nothing to do with you, unless potentially, there's interesting questions as to, if they were on your insurance plan and you're the person who's got the insurance plan, are you still going to be responsible? Probably. So it depends on the situation, but generally for bills that are just in their name, the estate is responsible. You are generally not responsible for their debts, okay? And that would also include other liabilities, like if they had a lawsuit against them, or their business was in bankruptcy and they had personal liability on contracts or other obligations. You're not obligated to pay those debts. Those are the responsibility of the deceased person's probate estate, okay? And there are very particular rules in Missouri about how that you have to follow if you want to get paid as a creditor in Missouri. And this is important when you're as important when you're defending against them as when you want to assert a claim. Let's suppose either you are representing an estate and trying to protect against claims, or alternatively, suppose that you paid for a funeral bill or something like that, and you would like to get paid back. The proper way to do this is as follows. Generally, you need to file a creditor claim in an open, full probate case. All right, so in Missouri, generally a full probate administration is only done when the value of the decedent's estate, all the property left in their name, exceeds $40,000 in value, less liens and encumbrances. So mortgages and car loans, things like that. If the value of the estate is lower than $40,000, you're generally not going to open a full probate administration. In those situations, the only way to get a creditor claim validly filed is to force open a probate estate. And this is as true for an outside creditor as it is for you if you're trying to get a creditor bill paid. And so generally, if you're like a credit card company or a healthcare company and you're trying to get paid, or you're a debt collector, most of the time those creditors are not going to hire a lawyer to open an estate and file a claim unless it was already open by somebody else, usually one of the family members, okay? Now, one of the most important requirements in addition to the fact that you have to file it in probate court through an attorney, if you're a corporation or an entity, you have to have an attorney to file that creditor claim, because in Missouri, you cannot represent yourself in court as a corporation unless through an attorney, except through an attorney, okay? The other very important rule when filing a creditor claim in Missouri is that it has to be done on time. You've got to file that claim within the time limits. There is a hard 1-year limit on creditor claims from the date of death. So if a creditor claim is not filed in probate within a year of death, it's barred forever in general. The other rules: if an estate is opened and a full estate is opened and letters of administration or testamentary are issued to a personal representative and they take over control of the estate, that gets published in the newspaper. So when that publication happens, that starts a 6-month and 10-day clock. So if at any point during that 6 months, a creditor, so then that starts a 6-month clock. So a creditor from that point has 6 months to file a claim. Or if the creditor is directly and personally notified of the opening of the estate, they only have 2 months. And the rule is that it's whichever deadline is sooner. So, let's say you open an estate in the 11th month after death, and then you get letters of administration in month 13. So after a year of death, that's fine. An estate is open, but it has been more than 1 year since death. So a creditor is barred. So it's very important if you're going to open an estate near that 1 year deadline, especially if you have your own claim for like a funeral bill or some other cost that you've incurred, very important that that gets filed right away, okay? Very important to get those filed because you don't want to deal with timeliness problems. The probate laws in Missouri are very, very strict on getting that filed on time. But it's also an important thing to understand when you're dealing with the deceased person's bills. What the implication is that generally those bills do not need to be paid. Most of the time, those bills generally do not need to be paid unless the creditor goes through all the hoops that they need to do to get paid. So they need to file a claim on time, in probate court, in a full probate administration, and then they have to show up at court. Because what a good attorney will do in defending against those creditor claims on behalf of the estate is they will notice them for hearing, which is essentially just a miniature trial where the creditor will need to put on evidence about the value of the claim, how they have rights to file the claim, if they're a debt collector, did they buy it, where's the contract that says they bought it. They have to prove up every link in the chain. And most creditors don't do this. They just don't. They either don't file at all, in which case you can completely ignore the mail that they're sending you, or they do file and they don't show up to the hearing and they get thrown out. So the vast majority of creditor claims, especially from outside corporations in Missouri, can basically be ignored. The one exception to this are sometimes you got to be careful with debts or obligations of the deceased that if you don't pay them could result in a forfeiture of an asset. So like, let's say mom died, she had a mortgage on her house. In Missouri, there is a 6-month moratorium where a mortgage company cannot foreclose for 6 months after the date of death, even if payments cease, right? So if nobody's paying the mortgage, they still cannot foreclose for 6 months after death. There's kind of a waiting period where you can hopefully get into probate and get control over the property before foreclosure occurs, okay? But you don't want foreclosure to occur if you're already past that 6-month window, or you just want to keep the loan current because you don't want to have to bring it current when 6 months hits. There could be any number of reasons you want to keep the mortgage current, but it can be very risky because the property can be foreclosed at any time after 6 months of death. So if the mortgage isn't being paid, then you could run into a situation where the house goes into foreclosure before you can try to access it through probate, and the process might take longer than the foreclosure process does. So it can be a good idea to float that mortgage depending on the circumstances of your particular case. Sometimes it's not a good idea. Sometimes if there's an adversarial issue and there's going to be a dispute over who paid how much and are we going to get it back and yada, yada. Sometimes the better thing is just to, let your hands, keep your hands out of it and, request expedited processing by the court, and hopefully we can deal with it before foreclosure happens. But those kind of debts where something could be lost if you don't pay them, it can in some cases be a good idea to keep paying those, even though the estate is technically obligated and even if no creditor claim is filed, because secured claims, claims like mortgages, like loans on a car, those don't need to be filed in probate in order to be enforceable because those are claims against the property. They're not claims against the estate, right? And only if those claims are unsatisfied or if there's a deficiency balance, like let's say they foreclose and they don't get as much money as they thought at foreclosure, and the deceased still owed them 30 grand. Well, they would have to go against the estate for the deficiency of 30 grand. So that's kind of how that works. The other kind of bill that you might want to consider paying, especially if the deceased had real estate in Missouri, are things like the utilities on a house. And the reason for that is that depending on what time of year it is, if we're going into winter, for example, you can see, you don't want your pipes to freeze in your house and burst, in the deceased person's house, and burst and cause damage to the property while you're trying to get probate going. So you want to make sure that the electricity and the heater is still on so that we're not going to have any damage to the property. You want to secure the property. Make sure that there, if there is a security system, you could consider continuing to pay that security system, especially if you don't live close by, to keep an eye on the property in case somebody were to break in or something like that. So these sorts of debts, it can in some cases be a good idea to continue paying, even though nobody is technically obligated other than the deceased person's estate. So in general, the takeaway you should get is to not pay bills unless your attorney specifically tells you that you should, all right? Because you don't want to end up paying bills that you didn't know or that nobody owed and throwing money down the drain. But it's important that whatever does get paid, either valid bills or expenses that you need to incur on behalf of the estate, such as by paying an estate clean-out company or an auction company, it's important that you document those very carefully and keep copies of receipts and canceled checks so that later when we need to show the court what you spent, what came in, that you can do that, right? That's a very important part of the closing of the probate estate. So if a creditor calls you, what are you going to do? You're going to hang up. In general, you're not going to answer that. If they say, hey, we're trying to get bills from you, you're not responsible for paying that. If they're sending you letters in the mail, you're not responsible for paying that in most cases. Now, again, if you personally are on the hook or on that account, on that credit card, make sure that you talk with the lender or the creditor or whoever it is and figure out if they believe that you're personally responsible or if they're only going after the estate. Sometimes that little clarifying call can help you breathe a whole lot easier. Check out some of our other videos on probate and the probate process if you have more questions or just want to learn more about how probate works in the state of Missouri. So if you like this video, like and subscribe, hit that bell down there if you want to get notifications about our new videos. But that's it for this time, guys. Talk to you next time.